A negative decision in an adjustment of status application by filing a motion to reopen and a motion to reconsider. I'm Sam Shihab.
I am Brian Burke.
And we're from the law firm of Sam Shihab and Associates. We practice immigration law throughout the U.S. and throughout the world. And today we're going to talk about a motion to reconsider and a motion to reopen. It's an area, in my opinion, that separates the men from the boys.
I like that, obviously. I was just gonna call it, like, classic attorney work.
Yeah.
If you find your case denied, you need an attorney, somebody to look at what USCIS said and call them on their baloney, most likely.
Every attorney can complete an adjustment application.
Yeah.
Not every attorney can do a motion to reconsider and to reopen in a way in which it drives the likelihood of success to its optimal point.
Yeah.
And I know this attorney can file the best motion to reopen and reconsider I have read. I can say that.
Well, thanks. I learned from you, Sam, and you taught me how to do them. And I only learned that by coming to you with one and saying, Sam, look what I've done. And he said, send it back, Brian. Send it back. Do it again. Well, Sam, I think we owe people an introduction video, and we'll say we'll be right back.
We will be returning in a second. All right. Number one, begin with the basics. Everybody call it MTR. And that's for a motion to reconsider. But you have the reopen.
Yeah.
And these are two distinct legal motions, although they're combined in one brief, but they follow different legal standards.
Yeah.
The motion to reopen is when you're introducing new facts that were not available at the time the government have considered the application, and therefore you believe these facts can turn a negative decision into a positive decision.
Yeah.
And on the reconsider, Brian, what is it?
Reconsider is essentially
new law.
Yeah, not new. I mean, you guys got the law wrong.
Yeah,
the law says
yes.
My case should have been approved, and you guys have misapplied it. So that typically entails, digging into what they said in their decision notice in the case, and saying, well, here's the legal conclusions they came to, and if pointing out the holes in those, here's where you guys got it wrong, and applying the law that you are bound to obey.
Yeah. So in my judgment, in having done motion practice for 3 decades, and you've done it for more than 10 years, Brian, close to 3 decades, I haven't crossed 30 years. To me, I envision the process of filing a motion is having the needle switch from the right, extreme right, to the extreme left. And there are 2 steps. From the right to neutral, and from neutral to positive. Stated differently, there is a momentum heading in that direction. To switch that momentum into the other direction, it requires to slow down that momentum to a 0 and then let it move to the other direction.
What momentum are you talking about, Sam? I'm having trouble following.
I have a government negative decision. Mm-hmm. I have to neutralize the government mind about the case from negative to neutral. And then I got to take the government's mind from neutral to positive.
Yeah. You got to make them do a 180, essentially.
Yes,
yeah.
and it's a 2-step for me to a neutral. So, and I think, there are cases that are not savable. There's no question about it.
Well, yeah, it is possible to get your adjustment of status denied for a reason that is unrecoverable. A serious crime.
Yes.
You hit somebody. You hit 10 people with a bus intentionally. We don't like murderers in this country. You're done.
Yes. Yes. But the truth of the matter is that most cases have an opportunity, a realistic opportunity to turn them in a positive way.
Yeah. People come when people get denials of green card applications. They'll call us and say, hey, I filed my green card, it got denied, can you guys help me? and more often than not, we'll say, it's pretty clear they've, gotten something wrong here for sure.
And I have to say this because if I'm going to have to be honest, I'm going to have to be honest. This one area of practice is really difficult for the client to decide which counsel to go with, because they can go one attorney and they can call them X dollars, and then this other attorney can call 3X, and then the other attorney call 4X. You really need to go with the attorney that you believe has the ability. And it could be one of those 3 attorneys. You don't know. So it is not the cost that drives the decision, is the competence and the track record of the attorney. I have seen unbelievably drafted motions that are very impressive, and I've seen stuff drafted that even a first-year law student would be embarrassed to draft in this business. This is not about completing a form, Brian. This is about really, like you said,
persuading,
lawyering.
Yeah.
This is about taking this case and wearing it. You wear that case. You live it.
It's cut it open and live inside it, and it's not. Yeah, doing one of these cases, it's not something cursory. It's not something, it's not something I'm going to ask anybody in the office to help me with. I'm not going to ask a paralegal to complete the forms. I'm going to do them, all myself entirely, and I'm going to basically read every word that USCIS said in this decision notice, because honestly, all of those, almost every word in there is going to be legally significant, You
got to pick it apart. You have to make the government feel that with this decision as drafted, if it is taken to a supervisor with your motion, they may be embarrassed.
Yeah.
But with all the errors that they've committed in adjudicating this case, and you want to convince them that it's in their best interest to just get this case approved.
Yeah, I mean, usually when I talk about, immigration in general, I'd say, you want to have the most plain, mundane case that they've ever seen before. Something that looks just like the last case they did, just like the next case they're going to approve. Everything flips upside down when you're talking about motions to reopen or reconsider. You want to make this look like the most extreme, egregious example of a government mess up ever. It's not a lot of time, when, you're dealing with, filing cases or answering RFEs, for example, you're going to be very nice, very deferential to the government because you want to try to make friends with that officer as best you can on paper. But once they've denied your case, there's no deference to them. They can't shirk procedure anymore. You don't give them the benefit of the doubt on anything because, well, that's it. It's your case on the line. It's your green card on the line. And when it comes time to finally sit down and write one of these things, it's not just you're going to make your best argument, but you're going to make every argument you have every time the government failed to dot an I, cross a T. You're going to go after them from that. So let's really talk about maybe what goes into one of these things substantively, Sam. A motion to reconsider is about the law, right? When they issue a decision, they're going to say their decision is based upon X law, X bit of law. And you know what the very first thing I do when I get one of these things, Sam, is I go and read that law that they're citing. And a good chunk of the time, the law that they're citing to is, irrelevant or improperly applied. And you know what all that goes into, Sam? It goes into the MTR motion. It says, you read this law. This is what you think it means. Here's what it actually means, and here's 5 different reasons why your interpretation of it's wrong. My interpretation of it is right.
When you read a denial decision, the first impression as a client, you see, oh my God, I'm cooked. Yeah. They're making this most compelling case against me. I don't see how I can overcome it. You need to write something where the officer, when they read it, they say, oh my God, I'm cooked.
Yeah.
Oh my God, I'm cooked. How did I make this decision?
Yeah.
And that's what you have to do. And that is not something that everybody can do.
Yeah. It is
truly.
Honestly, it is a time-intensive task. When we start writing one of these things, usually if we're going to do one of these in our office, we'll have a talk about, and we'll talk with the client obviously in the beginning about, here's where we think it is. Here are 4 reasons why you think that is challengeable. Here's the 4 things we're going to argue in your favor. Now, you've written enough of these to know that, okay, well, you start writing these things. Here are my four issues. Well, it turns out 1 and 2 aren't that great, but in the process of finding out that 1 and 2 aren't that great, you came up with
5, 6, and 7.
Yeah, exactly. So it is research. I mean, you spend a lot of time reading the law. Basically, not only what the law says in fact, it's how it's been interpreted in court cases, how it's been interpreted in government policy, and you just kind of weave all these things together.
And the reality about court cases, you can find a court case that says anything you want.
Yeah.
You can find a court case out there that can say what you want it to say most of the time, which is an amazing tool for the attorney to put them together and present them. So the motion to reconsider, okay, is about obviously the law.
Yeah.
You have applied the law incorrectly.
Yeah.
And we have to mention it precisely. So you have to talk to it has to be very concise and very simple to follow. This is the law that we're talking to, and this is how you applied it, and this is why it's wrong.
Yeah.
And then move on to the facts.
Yeah, and that's the motion to reopen. Here basically, sometimes these denial notices say you didn't give us the facts necessary to approve this case, and that's where you say, whoa. Well, first of all, I'm always going to argue that the facts that were given to approve this case were more than enough. But you have an opportunity then to give them additional documentation, and there you
overcome.
To overcome.
Yes, the denial of an adjustment status can be devastating because if you are not on a work visa, you have 18 days in which your EAD is no longer valid, and your advanced parole is immediately ineffective. And you're accruing something called unlawful presence, which means that if you accumulate enough days in this unlawful presence days that, as of the denial date or 3 days thereafter, based on the notice requirement, they have to give you a notice for 3 in the mail, then there's penalties associated with that. Also remember that every family member must file their own motion to reopen and reconsider, even though the filing is superficial, because the filing will say that
please approve kiddos.
Look at my dad.
Yeah.
Read my dad's application.
Yeah.
Or read my spouse's application, and that's why you should approve me. Now, USCIS has an unwritten policy that says that if we approve the principal, we on our own motion are going to reopen everybody and approve them. But it's not written. I love policies that are unwritten because unwritten policies are not worth the ink that's written on it.
There you go.
It's
Very
worthless.
Nice. So
you got to follow those motions.
You mentioned, sort of the implications that you are left, no EAD gone in 18 days, AP gone immediately, adjustment of status denied, accruing unlawful presence. Now, people who have talked to me, Sam, will see me do this thing, or talk about, the benefit of having your H1B status and your adjustment of status. And this is kind of the classic reason why, if your adjustment of status is denied, that is devastating, of course. Right, and if you have no H1B status or other status in the United States, you will essentially have to leave the country immediately to prevent accrual of unlawful presence. But if you have that H1B status, H4, L1, whatever your status of choice is, still pending with still approved with USCIS, you have some comfort to know that you can go to work the next day and you're not accruing unlawful presence in the United States. 2, you know that you can fight, spend your time in the United States and fight with USCIS on the green card denial because, if you get your adjustment of status denied and you don't have any other status, there's a law that says basically up to 180 days, less than 180 days of unlawful presence in the United States, no serious consequences. It's still, you shouldn't do that, but no serious consequences attached. But basically, USCIS isn't necessarily going to act on your MTR very quickly. And then, suddenly you could hit a really serious spot. If oh shoot, my green card is denied, I file an MTR. If you're looking at that 180-day mark, you have a real serious decision to make. It's, well, I can stay past 180 days and risk that it's not going to be approved and the negative consequences that come with it. So if there's ever a reason why we say, maintain your H1B status, it's because that green card's not approved until it's approved. And, we've looked at the numbers on this. They deny about 1% of employment-based green cards. you don't know until the green card that is in your hand until that you're not going to be that person.
Yeah, two comments on your good analysis, Brian. First of all, the I-485 H1B is great, but also the I-485, a second I-485 is great. So if you have two 485s, one is denied, you're legal. You're not affected. And normally, if there is a retrogression on one of them, they're not going to touch it for a long time. That gives you plenty of time to fight this other one. So that's really an important point I wanted to kind of share with everybody. The motion is there's 30 days to file that motion. Not enough time, very quick moving thing, and there's a lot of work that goes into it to do it right. And then there is a minor exception that if the delay is beyond your control and at their discretion, they may accept a late motion.
But that's never something. Government discretion is something I don't want to hang your. Their grace is not something you want to hang your hat on. Basically, if you have a negative decision on your I-485, this is when you pick up the phone, call the counsel of your choice. Talk to somebody else too, because it's just a good idea. Multiple opinions, never a bad idea.
And if you receive a negative decision within that 30 days, you can file another motion. And we had the pleasure of filing a second motion within 30 days for a wonderful gentleman that came to us where his attorney got the first one unfairly rejected. So it came to us within the 30 days, and we filed our motion within the second motion within the 30 days.
So this case, that basically somebody filed a motion on behalf of this guy, and the government said, "Your motion's garbage, denied."
Quickly.
And they came to us and said, we did another motion. So
within the 30 days.
Within the 30 days, and they.
And that second case, as a matter of fact, was approved recently, and they got their green card, which is a life-changing event, right?
Well,
I mean, between denial and approval is between Earth and the moon. It's huge.
And that case, pretty clear cut. The one I know, the one you're thinking of, a pretty clear cut of somebody's green card improperly denied, and yet the government, was very happy to issue a very official-looking document saying, no green card for you. You haven't met the requirements. It's funny, Sam. I was at a.
But we have to go with a full press attack. So when the government does something like this, you got to create so much noise and so loud in your motion that they cannot even turn it off. I mean,
you can't assume that, oops, they just got one thing wrong. Maybe they just missed a minor fact, or they just misunderstood a minor thing, because they're happy. Tell somebody they've made a wrong decision, and those person's instinct is to double down and say, "No, I'm right. You're an idiot." Right. So you really had to go through that whole process that we discussed. It's dig down deep and pull it apart.
By the time they finish reading the last page, they say, "Oh my God!
I need to call my mom. I'm going to lose my job."
Oh my God! What is this? This is really something that is amazing. All those mistakes in my decision. Which, by the way, every decision, with few exceptions, but every decision got holes all over it.
I mean,
all over it.
Any decision, any MTR you win is a good one, and you're right. I mean, you talk about holes. I think about procedural stuff. It's what the government didn't do right in denying your case. And if they, maybe they did have a good reason to deny your case, but if they don't state it right in their decision notice, that is, your path, your door to reopen and open a case, which is always good.
So what's an MTR timeline, Brian?
So the government says they will typically get to make a decision on the case in 60 to 90 days, and that's great. In the meantime, your green card is toast. Just by filing an MTR, toast is a tough word, but it is. Just by filing the MTR, it doesn't reactivate your EAD, reactivate your advanced parole, or prevent any of those bad consequences from happening. However, if they approve your case, if they take your MTR well and your case is approved, well, they don't care about that stuff. They issue you a green card. So, that's really kind of it. Your case is in a sort of limbo while the MTR is pending. You don't know whether it's you get a receipt notice, and what you're really hoping for is you get a notice that says we've reopened this thing for you.
One of the things, Brian, that I always notice about dealing with MTR is extremely emotional issue for the client. And when the client is so emotionally involved, sometimes the client is...
I don't blame them. It's a green card, something a lot of people in our audience, a decade or or more.
Yeah, it's a massive pressure. But what happened for some people is they lose hope.
Yeah.
And they lose the will to fight.
Yeah, I mean, I think I know who you're talking about. Maybe about 6 months to a year ago, I remember.
Well, we see those all the time. I mean,
I have one in my mind, obviously, where somebody will call us and say, okay, well, this is rough, but here is a path where you can keep this thing going and open, and there's a reasonable chance you could see it overturned. And but if you're just you have to be willing
the will to fight. Yeah, if you lose the will to fight because I don't want to spend this money, if I'm going to lose, I have to go back home. Maybe it's just not for me. I'm not ready to take a case like this because obviously you just don't have you don't have a client.
Yeah.
You don't have somebody who's willing to fight.
One of the things we talk with people about, if they have a denied green card application is, what are your other options? And just because they deny one single case, it doesn't mean necessarily that, your path to a green card is fizzled out. I mean, it's possible for them to deny a I-485 adjustment of status application for minor technical reasons that wouldn't prevent you from, filing another I-485 application immediately. Yeah. And so that's something you can consider.
Interesting case comes to my mind. It took about a year to resolve favorably. Is this rejection based on a bounced check? Remember that one? So this case was rejected because USCIS rubber stamped on the check that was received and rubber stamped USCIS, Homeland Security or something, and covered it up. And the check was rejected by the bank because it was
modified.
altered.
I do remember this.
Altered check.
Modified document, yeah.
And we had to educate USCIS that what you're doing is breaking the law. You should not be touching that check except cashing it. Yeah. You cannot rubber stamp. You cannot alter the
instrument. Yeah.
The instrument, right?
Yeah. And
the payee's name, which is U.S. Homeland Security, cannot be changed. You cannot touch that area. You have violated.
I say who the money gets paid to, not you. You can't modify my check. Yeah.
And we had to explain that to them, and we got a letter from the banks. We even pulled, was it IRS codes? IRS codes, or
I think I definitely remember going back
UCC,
to a lot of
UCC,
a lot of classic law school secured transactions sort of things.
Uniform Commercial Code, which is federal law, and showed them under federal law that they're breaking the law by touching that check. And by the way, they were doing it to every check, except that the bank that were in question said, this check is messed up, we're rejecting it. And they took the case, this kid's, it was a very, very high pressure situation for them, and was approved, and I think they got their green card, and life goes on. So that's the motion to reconsider. Anything we need to talk about?
No, I just, I think, what you were saying at the end there is, we talked about, generally, when you do that motion to reopen / motion to reconsider, it's a full court press. You go down all guns blazing. You're going to make every argument you can because you want to show the government they've been grossly screwing this thing up along, the entire way. But I mean, that just, the going down all guns blazing is just not limited to the case itself. It's all the other options out there. It's, you might still be eligible for another filing. You can resume your H1B status, and push comes to shove, it's also possible to apply for a green card, through the consulate, which...
Well, yes, but leaving the country is an abandonment of your motion, so you have to be put here in the U.S. you cannot really leave the U.S.
Well,
until...
if that's, in the event your I-485 application is clearly, let's say, denied for a reason, a technical reason that could be overcome by leaving the country and entering into the consulate.
Yeah, so yes, I think what you're saying is it's not only filing a motion, we need to look at all other options. As a matter of fact,
Don't put all your eggs in one basket.
Yeah, so I think for that gentleman that we were looking at, the most recent motion that we filed, I think under INA 245K, they were within 180 days, and therefore they could have filed a second adjustment of status. But we wanted the first one to be approved.
Yeah.
So
yeah, I mean, this can result with okay, you're doing MTR to keep the one adjustment of status going, and you file another adjustment of status if you're still eligible to do so, and you just throw those cases out there, and as long Yep,
absolutely. Okay, wonderful. That's a motion to reopen and reconsider how to challenge your adjustment of status denial. Hopefully you never get a denial, but it's something that's very important to understand your option and the timeline, which is 30 days to act immediately, and it can be done. We will answer your questions when we come back. All right, this is when we answer your questions. Just remember, the material we present here is general in nature, is designed to give you general guidelines. Do not make decisions on your case without consulting a competent attorney of your choice. Obviously, because we're discussing topics or you're asking questions virtually to us, there is not an attorney-client relationship is established in that communication, but we would love to answer your questions, whatever they may be, on the topic in which we have information that we can share with you. Without further delay, let's take the first one from Noor M.
Yes. So here's the scenario. AOS pending with employer A, traveled on AP in using EAD. Can employer B file I-45 under EB2 when another I-45 under EB2 is pending? So I think, two questions here. So generally speaking, you can have as many paths to a green card as you desire. I mean, there's no guarantee that, that offer of employment from employer A is going to hold up until, a green card is in your hand. So certainly, pursue a green card through employer B. The problem I see in this scenario is, if you've entered the United States on an advanced parole, you may not be in, you're probably not in status anymore, H1B, L1, etc. And there's a general requirement for employment-based green card applicants to be in status at the time they file. Exception, INA 245K.
Allows for 180-day window.
Yeah. Of status violation.
Potentially filing.
Yeah,
the adjustment.
Something that should be analyzed very carefully for sure.
Through an attorney, absolutely. Yeah. Excellent answer. Next one from Shiva Varma. Thank you for the great work towards the community. You're very welcome. My priority date is 2013, and I have 2 pending adjustments, and also received EAD for both. I'm filing my H1B. However, can my wife continue with EB2 green card EAD? The answer is absolutely yes. Your wife can continue with EB2 green card EAD. Obviously, she is no longer on H4 by doing that. And if she wants to get back on H4, she may have to leave the country, get stamped if she doesn't have a stamp, and re-enter the US. Otherwise, being on EB2 green card EAD for your wife is something that's perfectly acceptable.
I think there's a bit of a follow-up question there. So,
second question, Go ahead.
Will there be a difference in using the EB2 or EB3 EAD? Any preference here? I think it probably means EB3 or EB2 EAD.
Yeah, which card do you think you prefer? Any advantages, disadvantages?
My honest answer on this one is to my knowledge, there's no clear government. I think the worry that people have, Sam, is that using one of these EADs is going to lock you into that case. Right, and there's no government policy out there, to my knowledge, that states that you do. So I guess I have to say I would have no preference. And I've never heard of them, saying, "Oh, you used one EAD, you're locked into that case." Not something they do.
No. Yeah. Son diagnosed with autistic disorder, CS marked as Class B condition in I-693 form. Can it be a reason for delay in adjudication of I-485? 4 months since respondent's medical RFE, still waiting under EB1. Well, first of all, I hope your son do well. I know it's a challenge for the family to deal with a situation like this. But our neighbor has a son who has similar condition, and we see them all the time. They're so dedicated. Something about a child who goes through this challenge, something about the family unity becomes so strong. That's amazing. I mean, if you believe in karma or whatever, of course, I'm not a doctor, but I've seen it. So we wish you the best. With regard to your question, this is not an excludable or inadmissibility, ground for inadmissibility to have an autistic disorder. And normally these are communicable diseases that are relevant. So I don't see any impact whatsoever on your EB1. Brian, you want to add anything?
Yeah, I mean, fundamentally, it seems like this. The question is, can it be a reason for delay? My answer to that question is anything can be a reason for delay with USCIS.
But that's not.
I don't think it should be. But anything is anything. I don't think this. So I guess fundamentally, this is not a question you'll never get an answer to. But fundamentally, I agree with you. It's not something that should prevent you or your child from getting a green card. And that's the long view you have to take. Especially
if you have medical insurance and medical coverage, and you have you're employed, so there's no.
They're delayed in processing
charge.
everybody's green card case. I don't blame you for looking for a reason why yours is being delayed though, but it's really a common boat to be in.
Yes. All right. So question from Noor M. Does the application has to be on non-immigrant visa to file second 485 in EB3? When one is already pending in EB2 and currently on EAD app.
Yeah, Noor's the one who had our first question there. And
double EB2, EB3. So I'm not sure about this.
Well, I think basically Noor. Well, I think that's the first question that came up, and Noor was basically saying, if you come back on an AP, can I do it? And I think he's asking the question that we already answered essentially, that if you come back on advanced parole, you're not in status.
Yeah. Yes, we answered that question. Let's answer one more time so he's clear. I mean, obviously, you come back on advanced parole, you potentially have 180 days to file an adjustment of status if you left through non-immigrant status. But again, this is something that you want to carefully have it analyzed through counsel to help you through this process. But there is an opportunity to file.
Yeah, I'd say the key word to talking to somebody about this potential scenario is INA 245K.
And also the fact that I left the U.S., I was on an H1B when I left the U.S. and re-entered on advanced parole, and I'm within 180 days, can I file an adjustment status?
Well, yeah.
Those are the facts, Okay, so Abil J. Take that one, Brian.
Oh, okay. So I'm a chef located in India with 2 years experience and 3 years degree in hotel admin and hospitality. Chef is eligible for EB3 skilled category. Spouse is from Nepal. Can I use cross-chargeability as I'm born in India? Man, Sam, this is good. This is a good question.
It's just a good question and a great case.
Yeah.
So,
there's EB3. People ask whether they're eligible for a certain category, right? And I sort of throw that question back at them and say, it's about the job being offered. So, a EB3 skilled worker, there must be a job offer to you requiring, at least 2 years of experience. If somebody is offering a permanent position in the United States as a chef and the position requires at least 2 years of experience, that position, as long as you qualify it, which looks like you would make you eligible for the skilled worker category. And again, a fun question, which is one that always makes me so happy. It's cross-chargeability. So spouse is from Nepal, and can I use cross-chargeability as I'm born in India? I gotta say, Abhi here says something that's interesting. Spouse is from Nepal. What really matters, Sam, is where your spouse was born. If your spouse was born in Nepal, There you go. That basically, for people who aren't aware, there's this concept called cross-chargeability, where if there's a couple, let's say, here's your primary green card applicant, you have an I-140 filed, and you go by your country of birth, and you're born in India, and unfortunately that means you're in a 10-year backlog category. But if you're married to a spouse who is from a country that, doesn't have that backlog, you get to take advantage of their, country of birth. So in this scenario, Abi would be able to get into the EB3 Nepal line, which is very short.
Yes. Now, a couple things here. You qualify for EB3 skilled category, which is lumped into the EB3 main category for the numerical limitations.
Yeah.
But remember, the number of years of experience, which is minimum of, since you have the degree, I don't know whether the degree in hotel and hospitality is more relevant, but the 2-year experience is critical for you in the field. And quite frankly, it has to also be from a different restaurant. So, you cannot have experience gained with the same employer to justify the green card for you.
Well, I will point out that he's located in India presently, so I'm going to presume he's sort of in the early stages, hasn't, committed to a green card process yet.
Oh, so you have a 2-year India experience.
Yeah.
So how would you bring him here to the U.S.? So you want to apply for a green card for him directly?
Yeah.
As he's working there and he has to wait. So there's a long wait under the EB3.
I was looking at that. So I'm looking at the December visa bulletin. If you're in the EB3 skilled worker category and you are getting into the Nepal line, that date is current. Final action dates for
what month is this?
These are the ones you had printed a week or two ago, December 2022.
Okay, so if his wife is born in Nepal, it would appear that category today is not backlogged.
Yeah. Now the problem is, and Abi, if you have an employer sponsoring you in the labor certification process, you will discover that it actually takes a long time to get through that process right now. But you're in a relatively quick line for a green card in the United States.
Yeah, so if your employer filed that labor certification or prospective employer filed that labor certification for you, if the category remains current, which we do not know, but assuming that, you're looking at realistically a year, 18 months to 2 years to be able to be here as a chef.
Yeah, Sam, I have a major problem now, though.
Yeah.
I'm hearing this question from Avi. He's a chef located in India, and I'm going to presume he's an Indian chef, and now I want to go, eat Indian food.
That is a problem. So after we're done talking, maybe we're going to go and have some Indian food. All right. So hopefully we answered that question. Let's take the next one.
So,
AK, son is 17. Priority date is August 2014 in EB2. And I'm assuming he is born in India. The I-140 is approved in July 2022. I-485 filed in September of 2022. Would my son be eligible for the Child Status Protection Act after he turns 21? Well, we are going to try to answer that question for you in general terms. But I can tell you the only way in which you can get a solid answer to that question is if you have an attorney to look at the actual documents so they can do the calculations, because the devil is in the details always.
Yeah.
However, so there is 2 issues here.
Yeah.
One is how many days it took for the I-140 to be approved in July.
I don't know if there's enough information for me to answer that question.
No, we don't have answer, but we will guide him.
Yeah, sure.
We will guide him through it. So the first thing you need to do is you need to look at how many days that I-140 remained pending. If it remained pending 6 months, then there is a 6 months credit you get after the son turns 21. If the I-140 was filed in premium processing, was approved in 2 weeks, you only get 2 weeks credit. So that's the first thing we need to look at. The second thing, which is more critical, is when the adjustment status was filed.
You're thinking about priority dates, final action current. So
whether it's a final action or current, we don't know.
So yeah, the general rule though is basically if you have an approved I-140 with a final action date that is current, and you have filed for I-45,
then you're locked.
You're locked.
So
locked
if
in.
you filed under dates for filing, and the final action date never came,
yeah,
then that would be an issue. I don't have all the dates memorized.
Yeah, unfortunately, I'm trying to think where the July 2022 visa bulletin was. I don't know for sure on that off the top of my head. It was all I know. It was moving a whole lot over the course of that portion of the year.
And if it crossed, and it became final action date, and then retrogressed on that date, potentially it's locked.
Yeah.
So there is a lot to consider here. To be able to answer the question. So hopefully we've given you some guidelines. But your son is young and you got plenty of time.
Yeah, I am hopeful that, let's make it a very easy analysis. Everybody, put your positive thoughts. I think it's, you have about 4 years and, at least 3 years until that child is 21.
Yes.
And there's a reasonable chance that that priority date may become final action current before then anyway. Let's not have to think about the CSPA.
Yes. I think there's a follow-up on this here, but I think it's the same information.
Yeah, I believe so. Yeah.
All right. So alphabet.
This is a question that's going to strike near and dear to my heart. USCIS is now saying that we have high rest of world demand. As per my understanding, rest of world demand comes from approved rest of world perm labor or pending rest of world perm, which USCIS thinks will be approved in this fiscal year. And there's another part. If perm approval takes more than 8 months to approve, then most demand comes from already filed rest of world perms.
Wow.
Here's the finale. In this situation, why USCIS could not predict this 4 months back when they repeatedly asked Indian nationals to move to EB2? I'm pretty sure I said this exact same thing, 1 week ago and the week prior. I mean, it really seems like they kind of ignored cases if they in fact have those cases for the rest of the world. It really seems like Sam, you said they found a warehouse full of them. They closed the door on those cases for a couple months and forgot about them and said, let's approve all these India EB2 cases. And to that I say, good for all those people who got those green cards. But it really seems like they backburnered a whole bunch of cases such that they could issue these, long pending cases. And why did they do that? Maybe because they knew, these cases are easy for us to approve. They've been sitting with us for 2 years. We haven't gotten to them yet. They've done everything. Let's just approve these things and give ourselves the pat on the back for getting 280,000 green cards approved and out the door.
What interests me is when we looked at the I-140 numbers that were published, when we were doing our predictions, we saw a very average rest of the world I-140 approvals. We looked at the overall approval and we backed out. We subtracted China and we subtracted India because these are the two backlogged countries in the EB2 category. And we identified that the rest of the world I-140 was reasonable.
Yeah.
Then 2 months later, they release
updated data,
revised data.
Yeah. So I guess
so tells me that's why I'm saying they found a warehouse, because they revised their numbers.
Well, one of the things Alphabet asked here is, it's he sort of presumes that they know when a perm has been filed, that it now takes 8 months to approve, then the processing of I-140. Time on top of that they know that person's going to need a visa. I question whether or not USCIS looks at Department of Labor perm filing data. I don't take that as a given. I think a reasonably likely scenario is they don't consider a green card, somebody be waiting for a green card to be in the queue until that I-140 is approved.
Yeah, but when you count I-140s and it's one number, and then you look at it 2 months later, it's a different number. That's the shocker for me.
Yeah.
So for me, that they don't know really what their numbers are. I mean, there's no question when they publish it and they revise it, and we've talked about that a million times.
Yeah.
I mean, that is a big concern for me and a big red flag that really they don't have a handle on the numbers.
Yeah.
That's really the bottom line. But ultimately, I mean, this country has a need for more green card than then they're willing to give out.
Yeah.
And that has to change. We cannot hold 700,000 or 600,000 in the pipeline forever.
Yeah.
And we cannot change H1B law and give people this second class citizenship almost. You have H1B perpetual, H1B almost when you have a green card.
Yeah.
And you can work under these conditions where you have very little freedom for decades. But we don't want to hand you a green card. You're here, you're living here, you're having a job, you're contributing to the community, you're paying your taxes, and you've been here for 10 years, and your children are now 8, 9, 12, 17 years old, okay, living in this country.
Yeah, and what I always worry, I will very much worry about that, poor kid who's not the one who's 17, it's the one who turns 21 and has to change to F status. The poor kid who's lived in this country the entire time and only
And knows no other country.
Yeah. U.S. government, if you can't get that F1 approved, sorry, my man, head on back home. You know?
Well, no, they're not.
Home is not there.
They're
anymore.
not going to ask you to head up back home because you're here. The problem is if there's an exodus of these people to another place in the world, they'll change the law because it's going to affect the economy.
Yeah.
But if there's no exodus and everybody's accepting the status quo, they're not going to change the law. We have, I don't want to go down the list, but we have 10 million undocumented aliens in this country, and they represent substantial majority of agricultural workers in California. People say it's all the tomato pickers in this country. If they go on strike, there's going to be no pizza and no salad in America. That's a revolution.
I'm more concerned about the pizza personally. Sam.
Well,
I'm just
I'm
kidding,
kind of
but
a salad guy. I like the salad, but I like the pizza
why
too.
not both of them? We'll have a nice meal out of it.
But can you imagine a world without pizza and salad? That's basically what your undocumented are doing. But as long as they're going to work and as long as they're illegal, we're keeping them here. And that's now their children are born here. Now their children are older and they're going to colleges and universities and they're still not legal in this country. Yeah. It's an absurdity.
Yeah.
So something has to give on this. But don't get me started here, Brian.
I think you just got started, Stan.
Yes.
So from G. Saxena, with EB3 I-485 closed, can we still use EAD/AP we got through EB3 I-485?
100%. Yes. If you have timely filed an I-485 in which was receipted and they cashed your check, and that's another second-class citizenship that they give you. Now they're going to hand you an EAD and advanced parole for a decade before they give you your green card. But you can use your employment authorization document and your EAD indefinitely.
Well, no, I'm
But you're concerned.
I think I'm interpreting this comment or question entirely differently. I think this person says with EB3 I-485 closed, as in USCIS. I'm thinking that sounds like an administrative closure of the I-485 case.
I'm reading this as retrogressed. With I-485 retrogressed, can we still use EAD and advanced parole we got through the EB3 I-485?
Okay. Well, I'm reading basically. USCIS sent me a notice, sent a notice saying, we're closing out one of your I-485 cases because.
Well, if there's a denial, so closed meaning that they have rejected.
I've heard of this. I was just talking with Attorney Joe in the office. Like he said, Brian, I just got an email from a guy this morning. It said USCIS. I called them on the phone. I don't trust anything they say on the phone. They said, oh yeah, we administratively closed. Your I-485.
You got to file a motion. So you got to file a motion to reopen and reconsider, and you get.
If it's a scenario I'm talking about.
If scenario he's talking about as soon as possible.
Yeah.
100%. So you have if it's closed, meaning denied, really you have 18 days on your EAD. And your advanced parole is dead and it's not available.
So it's worthwhile to point out. This is where we say the devil's in the details. In this
well,
forum.
I'm glad you're sitting here because you had a suspicious eye as I'm talking about it because I assumed retrogress.
Did I just look like I wanted to punch you in the face and say, "Oh, this guy, what the hell is he talking about?"
No, you didn't look at that, but you looked like you were really not buying into it.
Yeah, fair enough.
Yes.
All right.
Yes.
So, not original name. I like that not name.
Any insight on the EB1 for India? Will it retrogress in January? If yes, how far dates will go? I think we have been told that retrogression is very possible for
Yeah.
the rest of the world.
For the benefit of everybody, I'm
January.
happy to read aloud what it says,
Yeah.
making sure I'm reading the, Visa. It says on the heading, on the visa bulletin, at the end of the visa bulletin, read the end of the visa bulletin, folks. There's all sorts of bonus stuff on the end where they have all sorts of commentary on what's going on, even if you're in family-based categories as well, if you happen to be watching us. But here's what it says. Visa availability in the employment first category for China and India. Increased demand and number use in the employment first category combined with decreased visa number availability for fiscal year 2023 compared to fiscal year 2022. I'm bothered by that part, Sam, because there's still more than is available this year than there is in a normal year. Will most likely necessitate the establishment of final action dates and application filing dates for China and India in the coming months to hold number use within the maximum allowed under the fiscal year 2023 annual limits. This situation will be continually monitored and any necessary adjustments will be made accordingly. So it seems likely that it's coming in terms of how much. I'm gonna kind of have to agree with our question asker here that there is such little data here, and the very little data that we thought we had a handle on from USCIS in the context of the EB2 rest of the world information that they were putting out there, essentially in court cases. We don't have anything like that right now. But obviously, anybody out there who has, any sort of insights, if you might be involved in a litigation or something like that, and you happen to have an insight, we're always happy and interested to hear those sort of things.
Yep. All right, so we got a follow-up here from Samfax. If one's I-485 is pending, and if he thinks there are chances of denial due to past unlawful presence or unlawful employment, can he go out of the U.S. and re-enter on H1B to use 245K and come clean? I hate to say this, but normally there's a lot more details to be able to give guidance.
Yeah.
So, but these are general information. Normally, for that specific adjustment of status application, you leaving the country and coming back does not clean up this specific adjustment application.
To use a metaphor, the horse has already been let out of the barn.
Yes, for that adjustment. However, if there is a concern about unlawful status or unlawful employment issues, the very first step is to assess it. Contact an attorney of your choice that you trust and engage them to evaluate. Because the answer could very well be, don't worry about it. Who cares? You're fine. A lot of time, this is the answer we give. If there is a problem, then the next step is how to remedy.
Yeah.
And how to remedy, it depends on what has transpired and what it is that we're trying to remedy. That allows us to give guidance on how to do it. But for this specific adjustment, leaving and coming back doesn't fix it.
Yeah.
Is that a good answer?
Yeah, I think that's a pretty good answer.
All right. I think there's a follow-up. Take that one, Brian.
I don't think it's a follow-up, but sir, in how much time are we allowed to file appeal for closed I-45 due to duplicate I-45 and EB2, EB3? So
That's an excellent question.
this is the same person who asked about that, I think. Yeah.
So I don't think it is closed.
Oh, it is. Yeah, that's it right there.
Yeah. So absolutely, you're right on. So normally a motion is 30 days. However, if you haven't received notice, I would say it's wide open.
Yeah.
So that's number one. I mean, again, what's a motion to reconsider? It's about the art of the attorney and the ability of the attorney.
My very first thing, if somebody tells me, "Oh, my case has been closed by the government, administratively closed," I'd say, "Well, I'd like to see a notice stating that." Oh, and well, you don't have a notice? Well, they haven't met the legal requirements to
close the
that case.
So you need to file a motion to reconsider right away. And also there is a provision that says you can go beyond 60 days.
Under reasonable circumstances.
Under reasonable circumstances, due to a hardship, within discretion. So, but also there's a notice requirement for them. So there's all kind of stuff here that, for me, and for you, Brian, the juices of a motion, the drafting of a motion to reopen begins in analyzing the case.
I like this. We both organically started doing
Drafting
this. We're about to
it.
start talking at one another. I mean, it's a funny question for me. Is if they haven't, first of all, if they haven't notified you, I'd say your I-45 isn't denied at all. You know.
But it looks like they've closed it, which is something stupid.
Yeah, I mean, yeah, but if they report your case, your
I would
case,
definitely begin with a motion right away, trying to clear this thing up right away.
yeah.
I mean, yeah, discuss it with a qualified attorney that can help you, but
Yeah.
absolutely, I wouldn't back off.
Yeah. Fundamentally, you're entitled to whatever I-140s say you're
They
entitled to.
took your money.
Yeah.
I mean, they're going to give you your money back?
Yeah. I mean, the fundamental response, Sam, for me is, no, guys, you can't do that. I'm entitled to whatever path to a green card, whatever door is still open. I'm entitled to whatever path is still open. And you guys can, yeah, of course you can deny one of these cases after you give me a green card.
I'm glad I didn't bet with you on that one.
Yeah.
Here's a clarification.
Yeah.
No, you cannot use the EAD. Well, that's an excellent question. Let's talk about that for a second. We have a couple minutes here, and we'll take the next question here so everybody's being answered. I haven't received an administrative closure notice. Can you use the EAD in advanced parole? I would say 100%.
Yeah, they haven't done anything to take away that
Yeah,
EAD.
you haven't. Yeah, if you have received a notice of administrative closure, then I would say yes, you cannot use it. But if you haven't received anything, you're 100%. You haven't changed your address. Your attorney hasn't received anything, because notice can be given to you or to your attorney, by the way. And a notice to your attorney is a notice to you by law. So if your attorney has not received it, you haven't received it, you can certainly continue working, but be 100% sure that your attorney hasn't received it. Otherwise, you'll be...
Yeah, I mean, administrative closure is something that makes me go, oh, baloney.
Yeah, administrative closure only is applicable. Number one, it really doesn't exist. They have only one of two choices, Brian: approve or deny.
Yeah.
You don't have administrative closure is garbage. There's no law that allows them to do administrative closure.
Yeah. I mean, so again, if they had a green card in your hand, I'd say, well, you got a denial notice saying we were denying this case because we approved another one. Sure, but yeah, this I don't like it.
Yep, I don't either. All right. Ajay Shah, could you please tell us the list of documents needed while entering back into the U.S. on advanced parole?
So
The advanced parole document.
the advanced parole document.
The passport.
Yeah.
Okay. Those two almost sufficient. I would add a few other documents.
Yeah. So yeah, I fully agree. Advanced parole document and passport, and the rest I would call gravy. I would say, a copy of your I-45 receipt notice to evidence that your I-45 is still pending with USCIS. Because,
Letter from your employer.
Yeah, saying, we're still supporting this green card application. I'd say you're pretty good after that.
Mm-hmm.
Yeah.
Yep. And do not schedule a tight connection.
Yes.
Because it may take some time. Old Lloyd. All right. I'm a physician. My EB2 was approved recently. My wage was $210K in my labor, but I was making more than $1 million. Do you think at the time of naturalization they might make this an issue? I don't think at the time of naturalization they have access to this information necessarily. They don't even look at tax returns. However,
So your answer is, the simple answer is, I don't think they would look at that, right?
well, yeah, but that's not really the answer to the question.
Yeah.
The answer to the question is this labor certification valid because really is it a true and honest test of the labor market?
Yeah.
So there's a lot going on here in this question that concerns me. There are two issues here going on in my mind. Whether they can catch it and what is the law. Whether they can catch it, not likely, low chance in general. What is the law? I see a lot of issues.
Yeah.
The first issue that jumps at me is whether or not this labor certification was done properly, in good faith.
Yeah, I mean, if basically, if I don't know when this labor certification was done, but if you were getting paid $1 million and the employer put, $210,000 on a labor certification, that's
I'm assuming his salary was $210,000, but he was making some kind of a bonus program, or I don't know what's going on here. But maybe also he had also ownership interest, which is also creates a
great point for
big problem because
for
obviously
You're
interfering.
not supposed to have an ownership interest in the business, you can, but it's complicates the labor.
Well, you have to declare it
Yeah.
on the labor certification. If you declare that you're not, then that's a concern. So there's all kind of issues. If you're concerned, consult with an attorney. I see red flags, but I don't know all the facts
Yeah.
in reality. All right. So Suresh, hi. If USCIS accept 485 application based on filing date, usually they do in January for a few months. Child age is not locked? Question mark. For the day, for the filing date, filing at that time, it is not, does not lock it. Now, if that priority date moves to a final action in the future, it could lock in the future. Yeah. But yes, if the final action date did not get to your priority date, then there is no locking under the Child Status Protection Act.
Yeah.
And we have received enough questions and answered enough, and it's 7:02 p.m. Thank you guys for listening to us. Happy Thanksgiving, you all. Happy